Have you ever wondered how a farmer's traditional seed variety and a scientist's newly bred crop can both be legally protected? And who actually decides who owns a living plant? In today's session, we'll understand protection of plant varieties and farmers' rights, along with biodiversity protection, covering the PPV&FR Act 2001, the registration process, the Biological Diversity Act 2002, and international agreements like the CBD, Cartagena, and the Goya Protocols. By the end of this lecture, you'll clearly understand the rights, durations, and authorities involved, all of which are extremely important from an exam point of view. Let's begin by understanding protection of plant varieties and farmers' rights. A plant variety is a specifically selected group of plants within a species that shares common characteristics. Protection for new plant varieties is provided through plant breeders' rights, PBR, granted to the breeder. Plant variety protection is provided under a unique sui generis system designed specifically for safeguarding biodiversity, genetic resources, and newly developed plant varieties. Under NEED, IP protection of newly developed plant varieties offers a reward system for breeders and encourages them to develop new plant varieties. Remember this because it is frequently asked in examinations. The term sui generis system is very commonly tested, so make sure you understand it means a unique, standalone system rather than a form of patent. Moving on to international treaties and Indian context for plant variety protection. Under international context, the first treaty is UPOV Convention, Union Internationale pour la Protección des Obtenciones Vegetales, 1961, Paris. Its English name is International Convention for the Protection of New Plant Varieties. It provides intellectual property, IP, protection to plant breeders for new plant varieties and supports a sui generis system for plant variety protection. The next treaty is TRIPS Agreement, 1995. Introduced by the World Trade Organization, it requires member countries to protect plant varieties through patents, sui generis system, or both, and sets minimum legal standards for protection. Now, under Indian context, protection of plant varieties and farmers' rights, PPV&FR Act 2001. India adopted the sui generis system through the PPV&FR Act 2001. It protects the rights of plant breeders and farmers. The Protection of Plant Varieties and Farmers' Rights Authority registers new plant varieties and grants ownership rights. Think about this for a moment. Notice how India's own act, the PPV&FR Act 2001, is essentially India's response to the international requirements laid down by UPOV and TRIPS. Let's continue with Protection of Plant Varieties and Farmers' Rights, PPV&FR Act 2001. The PPV&FR Authority issues a certificate of registration for a new plant variety under the PPV&FR Act 2001. It grants exclusive rights to the plant breeder to produce, sell, market, sell, import, or export the registered plant variety. However, such rights are exempted for using the plant variety for research purposes. Till date, the authority has issued nearly 3,500 certificates of registration of new plant varieties. Building on that idea, let's discuss the other functions of the authority. The first function is developing distinctiveness, uniformity, and stability (DUS) test guidelines. The next function is characterization, documentation of registered varieties. Another function is compulsory cataloging of plant varieties. Following that, documentation of farmers' varieties. Then, recognition and reward for farmers and farming communities. Also, maintenance of National Register of Plant Varieties. And finally, maintenance of National Gene Bank. Now let's look at the duration of plant variety protection in India. Trees and vines, 18 years. Extant varieties, 15 years from the time the variety was government notified under the Seed Act 1966. Other crops, 15 years. The next concept we'll discuss is rights granted under PPV&FR Act 2001. The first right is plant breeders' rights, PBRs. The exclusive rights granted to the breeders to produce, sell, market, distribute, export, or import the registered plant variety. However, such rights are exempted for using the plant variety for research purposes. The next right is farmers' rights. The Act protects farmers and recognizes their contribution in conserving and improving plant varieties. The farmers' rights under PPV&FR Act 2001 are as follows. Rights on seed, save, use, and share seeds. Right to register and protect traditional varieties. Right to reward and recognition, farmers receive awards and recognition. Right to benefit sharing, share benefits from new varieties. Right to compensation for losses, compensation for crop performance failure. Rights against undisclosed use, protection from unauthorized variety use. Right to access to seed, seeds available at reasonable prices. Right to free service, no registration fees for farmers. Right against infringement accusations, protection from legal infringement charges. Remember this because it is frequently asked in examinations. This list of 9 farmers' rights is a very common long answer question, so try to remember at least 5 or 6 of them clearly. Let's shift our attention to Protection of Plant Varieties and Farmers' Rights, PPV&FR Act 2001, the process of registration. The registration of a plant variety is mandatory for farmers or plant breeders to exercise their exclusive rights over the plant variety. Let's look at the conditions for registration of a new plant variety. Novelty, distinctiveness, uniformity, stability. Now, the types of plant varieties registered under PPV&FR Act 2001. New variety, extant variety, farmer's variety, essentially derived variety. Keep this point in mind because we'll use it again later. The 4 conditions, novelty, distinctiveness, uniformity, and stability, often abbreviated as NDUS or DUS with novelty, are frequently tested. This brings us to the registration process itself. The registration of a plant variety is mandatory for farmers or plant breeders to exercise their exclusive rights over the plant variety. Let's look at the flowchart. You'll see the process. The process moves in a clear sequence, beginning with the filing of the application, followed by examination of the application, then DUS testing to check distinctiveness, uniformity, and stability, followed by publication for inviting objections, and finally, if there is no valid opposition, the grant of the certificate of registration. Notice how this connects with the conditions we just discussed on the previous slide, since DUS testing is exactly where those 4 conditions get verified. Moving further, let's discuss biodiversity protection. India is one of the world's mega-diverse countries. Although India has only about 2.4% of the world's land area, it contains nearly 7 to 8% of all recorded plant and animal species. Due to problems like population growth, climate change, and weak environmental policy implementation, many species are under threat of extinction. Can you relate this to a real-life example? This 2.4% land area versus 7 to 8% species figure is a striking statistic and a very common one-mark question in exams. One more important concept is Biological Diversity Act 2002. The Government of India established the National Biodiversity Authority (NBA) in 2003 under the Biological Diversity Act 2002 to conserve biological resources and their sustainable use. It advises the Government of India on conservation of biodiversity, sustainable use of biological resources, fair and equitable sharing of benefits from biological resources. NBA has established state biodiversity boards, SBBs, in 28 states to implement biodiversity regulations at the state level. Let's continue with the functions of the SBB. Regulate conservation of biodiversity, promote sustainable use of biological resources, ensure fair sharing of benefits from biological resources, grant approvals for commercial use, biosurvey, and bioutilization by Indians, monitor local committees called Biodiversity Management Committees, BMCs. India has more than 2 lakh BMCs functioning at the local level. Promote conservation and sustainable use of biodiversity, document local biological resources and traditional knowledge, preserve habitats, land races, folk varieties, domesticated animal breeds, microorganisms. This is one of the most important concepts in this chapter. The figure of more than 2 lakh BMCs functioning at the local level is a striking number that examiners like to test.
Finally, let's discuss international agreements for conservation of biodiversity. Convention on Biological Diversity, CBD. The CBD was initiated in 1992 and implemented in 1993 to conserve biodiversity globally. Two important protocols under CBD are: the first is Cartagena Protocol 2000, enforced in 2003. Focuses on biosafety related to movement of living modified organisms, LMOs. The next is Nagoya Protocol 2010, enforced in 2014, ensures access to biological resources and fair sharing of benefits arising from their use. Remember this because it is frequently asked in examinations. Students often mix up the adoption year and the enforcement year for both Cartagena and Nagoya, so pay close attention to these two sets of dates. Thank you. And that concludes today's teaching slides. If you found this lecture helpful, please like the video, subscribe to our channel, and share it with your friends. If you have any questions, feel free to leave them in the comments section. Thank you for watching, and I'll see you in the next lecture.